Good afternoon, Simba, and thank you very much for your time. You know, when we look at the three exemption permit regimes, from the dispensation of Zimbabweans project, which I must say included amnesty for Zimbabweans who had in fact obtained fraudulent immigration documents, to the Zimbabwean special dispensation permit, and then the current ZEP. These all had a sole intention of contributing to addressing the broader issues of security as a result of political and economic instability that existed in Zimbabwe during that period. Now, by its very definition, Simba, the term exemption means to depart from the standard criteria of qualification of permits. So do you, or at least do the conditions still exist in Zimbabwe to retain such exemptions?
Good afternoon. Thank you for having me on your show. Your question is multifaceted. I'll try and answer them in the categories in which you have raised. The conditions in Zimbabwe are still difficult. Obviously, we know that there is a economic crisis that has been in the country, but Zimbabwe's economy is growing. It is one of the fastest growing economies in SADC. But that said, the individuals concerned have established roots in this country. They've been here for more than a decade, living here permanently, and you cannot uproot and have over 200,000 people, indirectly, their families, moving in the space of a few months simply because this program has been cancelled abruptly. It's unacceptable. And we say it's illegal and unconstitutional.
All right. So, yes, you say the conditions do still exist somewhat, even though the economy is just trying to get back on its feet. But we all do appreciate that governments have a tough task of balancing their humanitarian efforts against the economic and political stability of its own citizens. Now, given our current economic climate, an overburdened health system and unemployment standing at 34.9%, can government honestly justify retaining such exemptions even if Zimbabwe is not particularly stable, as you say?
Okay. The Zimbabwean economy and the South African economy are not islands. Both economies are linked. In fact, the regional economy is completely linked. Removing 200,000 people, and obviously a larger number because they've got indirect, you've got family members, does not help the South African economy. In fact, it's going to damage the South African economy significantly. On a purely economic argument, it doesn't hold water. These are customers for the South African economy. These are individuals that are contributing their skills into this country. So I do not believe removing these individuals will improve the employment situation in this country. In fact, if anything, it's going to exacerbate more unemployment in South Africa if a huge number of skillful individuals who contribute to this economy are removed in a matter of months.
But then now, if I had to take you back to that argument of perhaps there being a legitimate claim that these people have been here for 10 years. I've heard that argument, that Zimbabwean citizens have that legitimate claim, 10 years, but if we were to say they have a claim to be naturalized, if we go back to the conditions, was it not that this was a special kind of arrangement where there should be no legitimate expectation outside of those conditions, that it was purely taking into account the conditions that existed in Zimbabwe back then?
Okay, that's a very good point. We have to understand that the law that governs South Africa is the Constitution. We cannot, and I've heard argument that this exemption permit is a special permit, and for that reason, we can treat Zimbabweans the way we'd like because they are on an exemption permit, which is a sort of favor that has been extended by the government, and that favor can then be retracted. That argument is flawed. It's flawed because the government exercises executive power. That executive power has to be consistent with constitutional norms and values. And the exemption permits and the conditions that derive from that exemption permit have to be in line with the best forms of administrative law and constitutional provisions. And our argument, also the Immigration Act, our argument is that, look, ordinarily, an individual that has been in the country lawfully, not illegally, lawfully in the country for more than 10 years, ought to be granted the rights of their residency. And that those rights cannot be retracted simply because they were acquired by a favor, if that's the suggestion that it was a favor.
Not necessarily a favor, but a special dispensation or a special permit regime that was created to address a particular need, which many would have assumed, or government would have assumed, was a temporary crisis. So this would have been a special regime that was created, and that if ordinarily one were to be in the country for 5 to 10 years, they can ordinarily be naturalized, but you'd have to go through the criteria of the ordinary type of a permit, be it a work, a study permit, business permit, etc. So you don't think that such an argument would hold? Because I've been listening on several stations where the minister has spoken on this matter, and he's been quite articulate, speaking on this particular situation, that there is the opportunity to apply for the other permits and within the set 12 months grace period.
Yes, I have heard the minister's comments. In many ways, the two of us are in a duel, obviously also still in the courts. Well, look, we have to understand, and I think this is something that the minister will have to consider, and maybe the other members of cabinet. The exemption permit is a lawful permit. It is not something, we cannot ignore the fact that 200,000 people have been in the country for more than 10 years on this lawful permit. What we cannot do, and what I would argue against,
but it would constantly be renewed. Pardon me, it would constantly be renewed in this instance, that they would still reassess and then renew. This exemption really is a departure from the standard criteria, wouldn't you say? So how can the same laws apply in terms of people being naturalized after 5 to 10 years? And I'm purely just playing the devil's advocate here, that these are some of the arguments that can be brought up as the minister in his absence today would have ordinarily brought up.
Yes, well, to answer your question, I think we're conflating permanent residency with naturalization, which is obviously acquiring citizenship. What I'm arguing for in terms of the people that have briefed our team is for permanent residency, because these people are here permanently resident. So what I would, in response to the arguments that you articulated that was presented by the Minister of Home Affairs, his view is that, no, look, they need to, they can't keep renewing. I would agree with that. What he should do is give people that are here permanently, who have been in school permanently, who have bought properties and are here permanently, the rights of permanent residency. That's what I would say, that I would argue. And I also say that, look, the permit that they had before, with the ZEP permit, which you can't find in an Immigration Act, is a lawful document. And what they should be migrating to is a permanent residence permit. And we can then all put this behind us, give these individuals the papers that they have deserved, they have worked hard for, they've contributed to this economy significantly. Many of them are not the refugees and asylum seekers that the minister spoke of. On that basis, I disagree with him completely. I have clients who are ZEP holders that are multimillionaires, even multimillionaires in US dollars acquired here from the industry, and employ several South Africans. We're talking about a situation where there'll be capital flight that South Africa has never experienced if the decision that the wrong decision that the minister has made plays out. We'll see what happens in the courts. We'll see what happens in the next few months.
No, we'll certainly cover that as it plays out in court. Thank you very much. That's Advocate Simba Chitando, representing exemption permit holders.